on this. All right, good morning and welcome everyone. We're delighted to share with you today a presentation and an interactive dialogue on immigration, legal guidance for international sustainability professionals. We welcome you from Stevens Institute of Technology. Dr. Sarkar is the founding director of the Master of Science in Sustainability Management program. He's unfortunately unable to join us today. I am your facilitator, Pam Samarco of Green Training Associates, LLC. I'm the program manager for Building Green Workforce Bridges career program here at Stevens. And we're delighted to have the Chugh LLP Law firm with presenters, attorney and partner, Mr. Min Kim, and attorney and partner, Ms. Mishita Jethi, to join us and have this wonderful dialogue. So allow me to introduce our agenda, and we'll have brief introductions of Mr. Kim and Ms. Jethi. We'll also have the students make a quick introduction, their name, their job title. They're seeking either an entry-level job or internship and the country of origin. Then we'll get down to business, an overview of immigration for business professionals, guidance on H-1B work permits, and securing internships and entry-level jobs. And we've got quite a few student questions. Then we'll open it up for discussion and more student questions and close. So we've got this list of student questions that we'll be running through. And what I'd like to do is introduce Mr. Kim to provide his introduction. And Mr. Kim, we look forward to having you here today. Thank you so much for joining. Please go ahead.
Thank you, Pam. Thank you for that lovely introduction. So on behalf of Chugh LLP, we consider it wonderful that we're starting to engage with the with Stevens Institute, and hopefully this will be the first of many future engagements moving forward. We understand that obviously immigration is a pretty dynamic field. It changes very quickly on a moment's notice. So we understand that the students there at Stevens might have plenty of questions as they kind of transition from studies to the U.S. workforce. So hopefully we'll be able to get to a lot of those questions and issues here today and moving forward as well. Just a little bit about myself. I've been practicing business immigration for about 13 years now, and for a good chunk of that, it's been exclusively business immigration. I handle some family-based issues here or there, but most of the time I represent, U.S. employers, small startups, all the way to, very large Fortune 500 companies, in terms of employing their foreign national, workforce, and, perhaps if the foreign national employees want to make the U.S. Their permanent residence, and all the way to securing their green card sponsorship and beyond to become a U.S. citizen. So it runs the entire gamut. Our firm and me specifically, handle H-1B, L-1, green card issues. I suppose I consider my field of expertise to be perm labor certification, as well as L-1 for intercompany transferees. Most of my time is kind of devoted into those kind of subsections of immigration law. And just a little bit about our law firm here at Chugh. We have multiple offices all across the United States. We consider ourselves a national law firm. A lot of offices in the West Coast and here in the East Coast too. And we employ a very large staff that's dedicated to immigration work. So that's a little bit about me. Let me introduce my colleague here, Mishita Jethi. Mishita, do you want to go ahead?
Thank you, Min, and thank you so very much, Pam. I echo, all the thanks that Min and Neha have already spoken about, and we thank Pam and Dr. Sarkar for allowing us to speak to this wonderful audience and hopefully continue this association for many years to come. A little bit about myself. I am an attorney and I practice business immigration in the United States. In my previous life, I have been an attorney practicing international arbitration in India. So some part of it is, personal for me, because I've gone through this journey of being an immigrant in India, from India in the United States, and sort of, restarting both in terms of career and everything else. So I take most of these questions and issues very personally, and I'm deeply engaged with our community, the South Asian community in particular in New Jersey. And very similar to Min, I think I wouldn't say my area of expertise yet because I'm still developing them. I've been practicing for close to about 8 years, but I think a majority of my time is also spent, with business immigration, particularly perm labor certifications for large employers who wish to sponsor green cards for their employees. So yeah, that's a little bit about me.
Welcome, both of you, and thank you so much for your dedication and commitment to ensuring our students have the right information, they're armed with the opportunity to proceed with their job applications and interview process and all of the important things for internships and entry-level jobs. So we're delighted to have your expertise here today. I'd also please invite Neha to say a brief hello, and then we'll go to the student introduction. So Neha, please introduce yourself.
Hi there. Good morning, everybody. My name is Neha Mahajan. I am the Business Development and Outreach Manager here at Chugh Law Firm. Like partner attorney Min Kim and partner and attorney Mishita Jethi, I would like to echo the same sentiment. We are all first-time immigrants here in the US, and we work for this amazing law firm. And immigration is such a large landscape, ever-changing. It's so hard to keep up with it. Sometimes even the attorneys at the office find it hard to keep up with all the news, all the instant changes that USCIS throws at us, really. So I can only imagine what a student must go through, especially when there is a lack of legit information available, and it's so hard to keep up with what's already going on in life, and then also to scramble the right kind of information. And that's exactly the kind of bridge we're trying to create with this partnership with Stevens. So please, stay in touch after the session also, and if there's any information that you think the session hasn't covered, I would leave my email ID right here and my phone number. Feel free to reach out. Thank you so much.
Absolutely, and I think this is one of ongoing conversations, and you all have walked this journey, which is what's powerful for our students that are at the beginning of the journey. So it's so wonderful, and you're right. The landscape of immigration is challenging because it's constantly changing. So your expertise is so important for the students, and an ongoing relationship with the students, and providing resources and insights, and as students being able to go to your firm and get direction from the right area, because your firm is global and it's extraordinary. So the opportunity is, if we don't get answers or can't answer questions today, we respect the opportunity to follow up, and then certainly make this an annual event and bring Chugh back to Stevens on a regular basis. This program is an ongoing opportunity for us to build a strong relationship with you. So we've got 6 students, so let's get to their names. Job title: internship or entry-level, job seeker, country of origin. I'm going to call out the 6 students so that we don't have to worry about who's next. So Yinka, why don't you start us off, please?
Hi, good morning. My name is Inka. I'm a master's student in sustainability management. So this is my last semester. I'm graduating this spring, so I'm seeking entry-level position, and I'm from Nigeria.
Thank you. And Brendan, how about you next?
Hi, I'm Brendan. It's a little bit embarrassing. I'm actually a U.S. citizen. My name was on the list, and I didn't know what this is about, so I just joined. But I have gone on. I went through this whole process myself years ago, from F1 to practical training to H1B, and then H1B, and then green card. So I can sympathize, like, the whole arduous process, and maybe I can share some experience if I'm just here for moral support.
Oh, we'd love to have you come. Thank you so much for joining us, and we welcome anyone on my distribution list. So a pleasure to have you, and absolutely, you've earned your stripes to be here. So we're grateful for your attendance. Pratiksha, how about you have your introduction? Thank you.
Yeah, hello. So I'm Pratiksha. I am doing my MS in Sustainability Management. I'm in my last semester right now. We'll be graduating in May, and I am looking for entry-level jobs, and I'm from India.
Wonderful. Thanks,
And I'm an
Tanvi.
architect.
Oh, and an architect, of course, sustainable architect. Brilliant. Alrighty. Tanvi, how about you next? Thanks, Pratiksha.
Hello, my name is Tanvi. I am from India. Currently doing my MS in Sustainability Management, second semester, looking for internships.
Excellent. Mridula, how about you?
Hey, hi, I'm Ridula. I'm also a second semester student in sustainability management. Right now, I am looking for internships. I actually have one in my hand, but yeah, that's it.
Excellent. Thank you. And Rex, of course, as a final introduction, please go ahead.
Hi, everyone. I'm Rex. I'm also actually a U.S. citizen, but in speaking with Pam and expressing some interest in maybe working abroad, she mentioned that I should hop on and listen to kind of what you guys have to say as you're a global law firm.
Excellent. Welcome, everyone. So let's get down to business. We have our questions, and I invite Min and Mishita to go ahead and take it away. Where would you guys like to start?
Sorry, I was on mute. Yeah, I mean, I suppose before we dive into the questions, I know that perhaps I know that it's a pretty varied audience here. U.S. citizens and foreign nationals and F1 status. I suppose since the topic initially was for F1 students looking to extend their stay in the U.S. Just really briefly about the H-1B program before we kind of talk about these specific precise questions. Just for the the F1s here, here in the meeting room, I'm sure everyone has some knowledge of the H-1B visa classification, the lottery process that that's currently in place by USCIS. So just some real-time updates. So the lottery was conducted. I suppose it's been 2 months now, and the agency, the government agency, has kind of recently revamped the process. I believe starting in the year 2020, where it's not so much the entire case has to be submitted to the government all at once, but now there's an initial registration period, et cetera. So there's been some controversy, for lack of better words, regarding the lottery selection program. There's been claims of fraudulent activity on the part of petitioning employers, and perhaps some foreign nationals trying to quote unquote game the system. So I suppose just broadly speaking, if I can provide some advice to the F1 students. I know that perhaps some are graduating their program and some are still in school and kind of going through the internship through this, and so this doesn't necessarily apply to them, maybe not for another 1 or 2 years. But compliance and fraud are kind of big ticket items right now for USCIS and Homeland Security. So just moving forward, if this is the near-term goal that you folks have about wanting to enter the lottery, wanting to be sponsored for an H-1B case, know that there's going to be companies out there who promise yeah, we can get you the H-1B visa. We work with affiliated partners here or there to increase your chances in being selected in the lottery. And I know that is a takeaway that might seem pretty advantageous and something that you cannot refuse. But USCIS and Homeland Security are kind of big on data mining nowadays and kind of sharing data, and they they're no longer going to be just content with kind of staying in the dark. And if someone has multiple registrations that are filed for them, that increases the likelihood that a flag is going to be raised and an investigation is going to be sought out. So I suppose just long story short, what I would advise is if you think an offer is too good to be true, you're receiving multiple, or you're receiving an offer from a petitioning H-1B employer saying that, oh, yeah, we have these other business partners that we work with, to increase your registration chances of being selected, et cetera, come with us. Once you agree to those terms, chances are going to be pretty real that USCIS is going to find out. And if they flag your registration case and they think that fraudulent activity is there, it could be entirely incidental and you might not have knowledge of that. You were just promised these things by the sponsoring employer. But the sponsoring employer, for lack of better words, engaged in unlawful activity. And unfortunately, you were the unknowing victim of that. But the result of that is that your registration is going to be rejected. And, the work that you put into, kind of doing the system and trying to do everything correctly, all that's going to be for naught, just because you tie yourself to perhaps a unscrupulous, U.S. employer. So tread carefully. If you're planning on entering the lottery system, next year or the year beyond that, know that, obviously in the real world, stuff like this happens. And we don't want you folks to obviously be on the short end of that stick. Mishita, is there anything that you wanted to add regarding the H-1B? Perhaps, do you want to go into the technicalities of it, just as a
Sure.
broad level?
Yeah. I think everything that Min said is absolutely right. And if I could just add, both from my own journey, and I think, in having practiced this for a while, I will say that immigration, right from F1 status all the way to citizenship, it's a very long process, right? And I don't say this to make it sound daunting, but what I mean is that since it is a very long time that these things are going to follow you, initial missteps, which right now might seem, I just want to somehow get my lottery picked up next year because I'm just looking to stay for a couple of years. I just want to, work in the US and that's it. And then I'm going to be gone. But you never know, you may eventually change your mind. You might want to get sponsored for a green card. Maybe, your eventual life partner may be a US citizen. And, there may be so many things that may happen and you want to continue staying in the United States. But everything that you do in your immigration journey kind of adds up, and you don't want a small misstep in the early part of the journey, as Min said, to have an impact, much later. We've had so many cases where people at the time of, the final application of the green card, that's the time when the USCIS, which is the agency tasked with citizenship and immigration, might say, hey, you know what, the H-1B that was filed for you in 2007, so today we're talking about, like, I don't even know how many years ago, was actually taken fraudulently, and therefore everything you've done since is wiped away, and you're charged of fraud and you're guilty of that. And these are people who've since 2005, 2006, they've been in the United States on various different visa categories. And all of a sudden, they might be faced with either, deportation or being told that now you have to go back to your home country. So I completely echo everything that Min has said, particularly in terms of potentially unscrupulous, employers. That's not to say that you cannot have multiple offers. I just want to make that clear that, for example, and I really hope that all of you, by the time you graduate, you are inundated with multiple offers by, different employers, and you have your choicest pick of employment. May you have, offers from Google and Meta. Oh, actually, maybe not those companies these days, but you know what I mean, like a lot of companies. And if they're legitimately different companies and, they are separate individual jobs, by all means, all of them should register you for the lottery. I think what Min is, clarifying is that it shouldn't be that you have like an agent or someone saying, hey, you know what, register with us. And we have like these associated 5-6 companies, which are essentially the same. They're just, they're probably shell companies. They just have different names, but the underlying employer or the people who own the business, including their business lines, their email addresses may all be the same. They probably all use the same means of filing the petition. That's when the USCIS takes it as concerted action. But obviously, if you have separate job offers from different and completely separate companies, that's absolutely okay.
Right, and then just to kind of close on that point, obviously, perhaps the objective of today's kind of webinar here is to kind of prop up the Stevens graduates in a way that you can be successful in interviewing with U.S. employers, and just having meaningful careers based upon the program that you're completing here at Stevens. But especially if you're coming from a foreign national background, just kind of reiterating what Mishita just mentioned. Whether it be like small employers, mid-size or large, but I've noticed that the tendency for larger employers that they're, really kind of big on compliance, and that they should be. I mean, they have high visibility. The government is kind of tracking everything that they're doing internally, especially when it comes to, labor issues. So that's the reason why, you want to set yourself up for continued sustained success. Yes, you want to get that job offer. Yes, you want to interview well. But once you are on board and, the employer, in order to continue to extend your stay here in the United States, they have to extend your work visa status, all these issues come to light. Like how legitimate was the F1 program? How legitimate was your OPT EAD, grant, and were you continuing to work and not failing to maintain status? So all that previous immigration history comes to light. And if you want to make the U.S. your permanent residence and eventually secure your U.S. green card, then we end up revisiting those issues as well there at that stage. So sustainability, continued progress in making the United States your residence, that is equally as important as, interviewing well and getting that initial job offer. So we just want to make sure that, that is, emphasized and kind of spoken into existence. But I suppose with that, perhaps we can pivot to, tackling some of these questions here, because I do think, there's some robust material to kind of go over. I take the first couple of questions to be kind of partner questions. I don't know, Mishita, perhaps you might kind of view the same as well.
Yes.
But if I can ask you about your take, the first question here reads, how shall students respond to standard job application questions? And then perhaps in addition to that, maybe you can kind of go into, how can students respond to interview questions to effectively encourage an employer to hire them? What's your response to those?
Thank you, Min. So obviously our expertise are, in business immigration. So while I absolutely cannot give tips on standard, answers to job application questions about, the subject matter itself, I can talk about how your immigration status might, come into question. I think the very first thing I would say is do not shy away from the fact that, you are a foreign national and you might require visa sponsorship. It is a fact of the matter, whether today or tomorrow, somewhere during the interview or perhaps at a later stage, that is going to come up. But I think what's best would be if you're armed with enough information and knowledge as to how to answer that question. So the one thing to know is that most US employers, they cannot discriminate on the basis of citizenship alone amongst various other factors. So unless you're being asked specifically, I don't think you need to, put it out on like your resume or anywhere. On the contrary, though, if you do happen to have a green card, I would say, put that up so that at least the employers know upfront that you probably don't require any visa sponsorship. But if you do require visa sponsorship, I don't think that you need to sort of broadcast it. But if it is being asked in either a screening question or perhaps in an interview with your manager or with the initial talent recruitment agent, if they do ask you specifically, and usually the questions come in the form of, will you right now or in future require visa sponsorship for continued employment in the United States? I think yes, the brief answer should be yes, because like I said, if not today, it will come up tomorrow, and you probably want to bring that up when it's being asked. However, I think in addition to saying that, yes, I think you should also be able to pivot and explain that hiring you is not just about your citizenship or the ability or the requirement of the employer to sponsor you, but you bring so many other things. And I understand from Pam that I think, a lot of students here and generally in this program have previous work experience. They've probably worked in their home countries, they have significant experience in their fields. So I would really leverage your previous experience to bring yourself as an applicant, where your citizenship or your requirement to be sponsored is only one of the minor hurdles, but everything else sort of checks the box for the employer. And today, most global employers have offices everywhere, right? So if you're the right fit, they should not turn you down merely because you require US sponsorship. And should that be, then it's a question, it's an ongoing question of how to figure that out. So I think that how to respond to the standard job application question, yes, you should tell them if you're asked, even if you don't broadcast it originally. And how can you respond to interview questions to effectively encourage the employer to hire them is to make yourself the best candidate for that particular job. Make sure that your skills match exactly what the job requirement asks. Make sure that you're able to answer all questions which are related to that subject matter extremely well. And in addition, you should always be able to give some options to the employer, because sometimes we've also found out, and perhaps Min can speak more to it, is that the employers, or at least the managers, may not be very comfortable or may not know too much about US immigration law because that's not their subject matter of expertise. You should be willing to give them options of, how they can onboard you. You can tell them that, well, for a couple of years, I can work without sponsorship. However, later I will need sponsorship, so that they can have a game plan ready. Right? The more time that you can provide them, the more information that you can provide them. I think most managers appreciate that information, where they're like, okay, well, so we know that we can have this resource for at least 1 year or 2 years. And in that time, make yourself indispensable to the company so that then they can, plan for your future.
Right. I I tend to agree with all those points, and yes, once you're like through the door, and once you're at the company, obviously that's a huge hurdle that's overcome, and you're there. And perhaps in part it's because that you had work authorization kind of independent to the work sponsorship need. You were granted a STEM OPT, let's say, and for the folks who might be knowledgeable about that program, it provides open market employment, an EAD card. It's granted for 2 years, post completion of your F1 studies, provided it's in a science, technology, engineering, math field. So all of these are tools, and I would invite that if you have any specific questions related to your personal circumstance, definitely kind of connect with an immigration expert. Whether it be our law firm or someone that you trust. Maybe you already have someone who counsels you in that regard, so that you'll be able to educate the recruiters. Because as Mishita correctly noted, a lot of times this is just above their heads when it comes to kind of understanding immigration issues. They think that folks are often just created equally. But the rules unfortunately are different if you are a non-citizen, a non-resident of the United States versus the other. I suppose one thing that I can add, since the topic is about the interview process here, is that to be flexible and agile, meaning that obviously there's a negotiation, and if it's a larger employer, chances are they have a more fleshed out legal department, so they understand these issues. I referenced that some hiring managers do not understand immigration issues, but if you're talking about larger, sophisticated employers, they've been through the ringer. They understand, some of the immigration consequences involved, and they might use that as somewhat of a negotiating tactic as well. Meaning that there's nothing nefarious about it, but they have rather strict company policies. You know, I don't know if the audience is familiar with premium processing or, you know, when someone should consider starting the green card process, but, you know, all these issues, you know, come to light. You know, even though the green card is not being talked about for many, many years you know, for someone who's just starting their professional career here in the US, kind of, you know, inquire further into that company about if they have a set green card program. Are they kind of set in starting the green card for the foreign national workers in year 4 or year 5 of their H-1B work visa? You know, I mean, it's entirely within your discretion to ask those questions. But if a company if a company does have such policies in place, in order to kind of, you know, cast you in a favorable light, excuse me, don't I suppose one thing that I can offer is, like, don't make so many demands. If a company is not willing to premium process any kind of non-immigrant visa petition, such as an H-1B CAP petition, or if their policy is kind of set on starting the green card in year 4 of someone staying here in the US, know that that policy is not going to be adjusted just because that you interviewed well at that organization. You know, so be willing to work with the employer, especially if they're a larger company. Know that they have very strict, you know, programs that are in place. And if you fit within that program because the hiring manager likes you, then know that, you know, obviously they're taking on some additional financial burden in paying the fees for your visa sponsorship, and kind of pushing them to go something beyond that might really kind of work to your disfavor. I suppose we can kind of jump to the next question here, Mishita. Number 3, what suggestions do you have about the job search process and finding companies who will sponsor students beyond the 3-year work permit? What do you have to say to that?
Right. So I think, you know, this question, I assume it's sort of targeted particularly for those who have their F1 STEM or who are at least eligible. That's why we're looking at the 3-year work permit. And as Min, you know, referred to previously, the OPT, the F1 OPT and the STEM extension, these are employer independent to the extent that as long as your employer is e-verified and has, you know, a training program set, which is usually a very skeletal requirement, you can work for any employer, and they do not have to sponsor you, so to say. You know, so I would use these 3 years as sort of, you know, I would be looking for different kinds of employers and using these 3 years as my ramp up time, I would say, particularly the first year, which is your OPT, right? I think because you're an absolutely free agent at that time, as long as you have an employment within 90 days, you know, after your EAD starts, because beyond 90 days, if you are still unemployed, unfortunately, you will be out of F1 status. So as long as you have an employment within 90 days, even if it's an internship, even if it is, you know, an unpaid position, I would use that time to canvas what kind of job opportunities are available out there, right? Because maybe that work experience will count much in your favor when you're looking for you know, your next job. Obviously, if you're you know, you're lucky enough and you have the right credentials, maybe you get hired in a very large organization from day one, which already knows everything about the H-1B sponsorship and is willing to sponsor you. But, you know, sometimes maybe that's not possible. Maybe you know, you start off with a smaller employer, and by small, I don't mean to cast aspersions on you know, their compliance or anything. It just, you know, it's a relatively smaller organization which may or may not have a robust immigration program, but that 1 year or 8 months or 9 months gives you enough of real-time industry experience, right, to build on your resume. And then in the next 2 years, which are your STEM extensions, you know, you can then perhaps apply to another company which maybe does sponsor H-1B visas. But I think I would always be cautious about, you know, like these timings, because as Min referred to earlier, right, the lottery is conducted only once a year, right? It's not a process where, oh, today I want to sponsor you as a company, let me file your H-1B and that's it. So the sponsorship is always done, or the lottery is always conducted once a year. There's a specific time in the year, usually around March or April, when the employers are asked to register the applicants that they want to eventually sponsor. So keep these days, these dates and the timings in your mind, where you know that you have 3 chances to get selected in the lottery, and utilize them well, so that if in the first year you're unable to find an employer that does the lottery, but you still have a job, I would say take it, build your resume, and be location agnostic. If someone is not in your preferred area of employment, but is perhaps in a different state, different city, I would say in that year, definitely take that offer, go, because the employer doesn't need to sponsor you. They just need to give you the job, and you can use that time to gain valuable experience. But by the time you're in your 2nd and 3rd year of STEM program, make sure that you've had that conversation with your hiring manager or your talent acquisition specialist that, hey, look, by the end of this 2nd year, I will not have work authorization in the United States unless the company decides to sponsor me and I get selected. And I would much appreciate if I can continue my association with this company. So what are your policies about H-1B sponsorship? So I think, having that honest conversation when you know that you are on a set time schedule helps. It may not be something that you need to do right off the bat the first time, but by your 2nd year and certainly by your 3rd year, you should be in a position where you ask these questions. And if the answers are not to what you like, right, at least you will know that in advance, and you have sufficient time to pivot to another strategy than finding out at the end of your 3rd year of STEM that neither will this employer sponsor you, and you're suddenly out of chances. So I think having a plan put in place by your 2nd year would be a good strategy.
I agree. And then perhaps just just really quickly to add to that, Mishita, she was great in kind of providing the conceptual and the theory behind these immigration recommendations when you're going through the interview process and looking for potential sponsors and employers. I suppose I can offer maybe some measure of real world practical advice in addition to that. And it's I mean, I don't consider myself an overly cynical person, but when you're dealing with immigration issues and employers that come in all different shapes and sizes and people with different immigration backgrounds, over the years and many years of practice, you kind of confront different job advertisements and such. So just really quickly, like I suppose a good way to phrase it is that no job. I mean, all job advertisements are not created the same. And what I mean by that is, depending upon how extensive a company's immigration program is and how many foreign nationals that it currently employs, they might just have to do job advertisements just as an exercise, meaning that they're not actively looking to hire anyone. Just because you see that company XYZ in, I don't know, Newark, New Jersey, or Palo Alto, California, and you're open to relocation, it kind of fits within the mold and the type of employer and company and industry that you want to work in. Doesn't necessarily mean that XYZ is looking to hire. Sometimes they just have to do that in order to comply with Labor Department rules. So know that such a thing exists as that. I'm not gonna go into the technicalities because I think it's beyond the scope of today's discussion and what to look for in terms of those job advertisements and know whether it is genuine or maybe something that the company needs to do in order to remain compliant. But know that just because you open the classifieds in your Sunday newspaper and see that, oh, this company is looking to hire, this company is looking to hire, and you feel like the job market is ripe for application. I'm not saying don't apply. Perhaps they really are, looking to hire, maybe they have a pretty large gap of vacancies there. But know that just because you see a company is looking to hire, depending upon the language that they use, I suppose if you've been practicing in this field enough, you know what to look for, and know that, oh, is this being done just in support of that company looking to sponsor a green card for one of their foreign national employees that it currently employs. And if that's the case, then there really is no job vacancy, and you might just be wasting your time and kind of following up with that specific employer. All right, moving on. Yeah, go
No,
ahead,
I was going to
Mishita.
say, so Min, let's say, all of this has happened, and unfortunately, one of the students is at the end of the 3 years either not able to crack through the lottery, just because they did not get picked up, or maybe because they did not find an employer who was willing to sponsor them. What would your advice be if at the end of the entire, OPT and the STEM extension period, towards the end of their F1 status, if they're unable to find anyone to sponsor them on H-1B, what are the other visa status that they could explore?
Right. So, I mean, that's always like the $1 million question, because knowing how unforgiving the lottery process is, we see that's more and more. I don't know if you referenced the number before, but just recently, a few days back, USCIS, the immigration arm for Homeland Security that handles lawful immigration, such as the H-1B visa classification, they recently announced, I believe it's around 780,000 or so H-1B registrations were received by the agency this past fiscal year. So know that that number was under 200,000 about 3 years ago. So we're talking about more than 3x in a span of 3 years' time. So it's just kind of erupting right now in terms of the demand for H-1Bs, and obviously with larger demand, but the supply has not increased because the supply is set by statute, by U.S. statute, at 85,000 visas per year. That just means the percentage of being selected for H-1B, visa lottery selection, just continues to shrink. So before, the percentages might have been 25, 30%. Now it's closer to the low teens, if not the single digits. So, this is obviously becoming a real concern as, people, continue their academic programs here in the U.S., such as, the enrollees here at Stevens. And as you plan to graduate, I want to continue living in the U.S. and start my career here. I keep, being rejected by the lottery system. I'm not being selected at all. Like, what are my options? So I suppose one immediate, option is, if you have based upon a familial relationship, if you are heavily involved in a serious relationship and that partner of yours happens to be a U.S. citizen or a green card holder, that's always an option. Immigration through a qualifying U.S. citizen or green card sponsor, always exists. If your partner is a foreign national, but if they hold a visa status themselves, so let's say, you're engaged or perhaps you're married to a partner who already is in H-1B visa status, perhaps you can look to file for a change of status to be their derivative accompanying family member, once the two of you are married. From an employer side of things, there are other visa categories, whether it be based upon nationality and citizenship, such as the TN visa for Canadians and Mexicans, the E3 for Australians, H-1B1s for Singaporeans and Chileans. So there are options available, and I suppose maybe some of the lesser common ones are E1 and E2 for treaty trader, treaty investor, the O1 for individual of extraordinary ability. So it's not for a lack of options, but obviously there's a reason why the H-1B is in such high demand, because that's probably the broad stroke that applies mostly to the foreign national workforce, and these other visa classifications they apply less so, because a lot of times the profile and the requirements for those visa classifications, it's not an exact fit. But it's definitely not for a lack of options. Mishita, is there anything else you wanted to add to that?
No, I think you covered all of them. And, again, if someone thinks that they're probably qualified for any one of these, visa categories, definitely reached out to a seasoned immigration professional who can guide you to your options, because I understand that some of these may not be employer specific, they may be about the individual themselves, whether through their own citizenship or through their extraordinary ability, so on and so forth. So speak with an immigration professional who can help you out. And I think dovetailing to that, I think the next question is about the EB2 NIW for recent graduates. I don't know if you want to take a stab at answering that question.
Right. So the EB2 National Interest Waiver, that's what NIW stands for. I suppose one thing that we didn't address is perhaps immediately going into the green card process, which is doable. There might be a misconception out there that just because someone is in F1 status, they cannot immediately apply for a green card. There's some precautions that the F1 student needs to kind of keep in mind if that's a strategy that they want to go with. And once again, I advise connect yourself with a responsible, knowledgeable immigration attorney and law firm that can advise on those tricky issues. But that's what the NIW is. It's a green card petition that skips over the lengthy labor certification process, so you can apply directly to USCIS. The NIW, it's a huge box of different requirements and things to kind of keep in mind in order to qualify for that. So I'm not going to go into the details too much here. But just practically speaking, if someone is applying upon the graduation of their program and their post completion F1, let's say they're starting to work on their OPT EAD, and if you want to just immediately apply for a national interest waiver, let's say you're self petitioning yourself, obviously the bar is raised. You're just starting your career, but basically you're attesting to the U.S. federal government that what you're currently working on has such incredible benefits to the U.S. economy, to whatever U.S. industry, whether it be environmental, conservation, et cetera, and you need to document that heavily. So it's a higher bar because, relatively speaking, you might be someone who has lesser experience than perhaps a counterpart who's been in the industry for many years, but it can be done, especially if the field of expertise that you claim is in such high demand here for the United States economy. And just to kind of add to that, if what you're considered an expert in is in a field that heavily involves research and development, then that kind of adds to the NIW being positively received by USCIS.
All right. I know that we're sort of, coming up on the hour mark as well. So we'll try and answer as many questions which are left and maybe try and bunch up a few of them. So let me try and answer the 7th question, which is for a job interview question, like, do you want to continue to work in the US or go back to India? How do we convey that we want to work in the US? So, let me try and answer this a little bit backwards, right? Sometimes the fastest way of continuing to work in the US is by not being in the US. And I think this sort of brings one of my favorite categories, which is the L1 visa. And of course, Min is, he's the expert at, and I'm sure he'll be able to give a more detailed answer, but just from a short perspective, sometimes if you don't get selected either in the lottery or for any reason, if you do not find a sponsor, but if you were working for a US employer in the United States, and if they offer you, relocation abroad, know that if you worked with them abroad for a particular amount of time in certain fields of work, in certain specific positions, After a while, you do qualify for another visa category, which is the L1 visa, which is the intra-company transferee, right? And this is special, or it's at least advantageous, because it does not require any lottery. It's not subject to quota. It's not subject to a fixed numerical limit. As long as the company is able to show that you worked abroad for for an affiliate or a subsidiary or a parent company, and you worked for a specific time period, which is 12 months or more, and the same company is willing to bring you back to a US employer in a position of specialized knowledge or managerial position, you would qualify for this L1, right? And in that case, the company could bring you back anytime. It doesn't have to be that, oh, we have to sponsor this person, only during April or March, so on and so forth. Obviously, there are certain, pros and cons. One of the cons is that the entirety of the L1 duration is either 5 years or 7 years, depending on the position. So it's not that you can continue to extend it, but you can reset that clock. And the other disadvantage is that, unlike the H-1B, you may not be able to change your employers as frequently or as easily, right? Because the underlying relationship of your employer, which is the intra-company transferee, is what makes the qualification relevant. So if you were working for company X and suddenly you decide you want to work for company Y, but company Y had no affiliate relationship with your employer abroad, you would not qualify for L1. But as a result of this, if you sort of stonewall your employer by saying, either I continue to stay in the US or I'm not going to work for you or something like that, I would say just, enlarge your thinking a little bit. And maybe if they send you back to India for a couple of years, and if you did not get sponsored on H-1B initially, you could come back later on L1. And overall, just, I think I alluded to this earlier, and Min said it in a different way as well, be a little agile in, where you're being located, be location agnostic, so long as the employer says, okay, maybe not today, but in a couple of years, we'll sponsor you. And if they do that, whether we like it or not, unfortunately, employment-based sponsorship is it's an employer-driven process, and sometimes you just have to be more agile. You have to be more open to relocations to be able to come back to the US again.
Right, and then perhaps just to quickly add to that point, I really like that phrase. Is a Mishita original, location agnostic. But I think that's extremely relevant, especially in today's marketplace. I'm sure everyone kind of reads the news. A lot of employers are now demanding their workforce to report back to the physical brick and mortar office buildings. Telework and telecommuting, everything that people were accustomed to during COVID. That's kind of coming to a close. And that's important, especially kind of representing some larger employers. Know that a general rule of thumb is that larger employers, even mid-sized employers, transparency and knowing what to expect for their employee population is really valuable to them. And employers, when they have their workforce remote and not being able to know where they are, what they're doing at what hour of the day, and everything is kind of just free floating out there, that really puts employers at unease. So a good way to counteract that is employers wanting and perhaps even demanding employees to report and start working at a physical office building. And there's real immigration reasons for that. It affects, especially if it's a foreign national worker, it affects how a green card is drafted and completed. It affects their underlying non-immigrant visa, work visa as well. If there's so many changes here or there, and employers are having a difficult time tracking all those changes, then it really puts the employer in a bind that they might be held liable for all these changes that are done. But also from an employee standpoint, from your standpoint, it affects your ability to maintain status. And if there's a disruption to that, then it really kind of impacts any kind of long-term plans of making the U.S. your permanent residence. So a good maybe broad brushstroke in kind of counteracting all those challenges is to have employees be location agnostic. And if an employer wants them to work at this facility in this state, then be willing to kind of be flexible and agile, kind of meeting that demand. I suppose the next few questions I don't mind quickly answering. It seems like they kind of have the same overall theme regarding a grace period. Number 8 asks, on an F1 visa, what is the grace period to find job after graduation? And then following that, some other grace periods as well. So, just broadly speaking, for a visa such as the F1, once that program concludes, there's a 60-day grace period to either leave the U.S. or perhaps change your visa status to some other authorized visa category to allow you to be in the U.S. But there's also a quote unquote grace period in terms of unemployment, because if you apply for your post completion OPT EAD, you're only allowed 90 days of unemployment. So if that's the grace period that this person is asking about, then it's a 90-day unemployment grace period for your initial 12-month post completion OPT. If you're on your STEM extension, so the 24-month STEM extension, then you're added 60 days on top of that. So basically, in the aggregate, you have 150 days of unemployment allowed. And any kind of unemployment beyond that is considered a violation of status. You have violated the terms of your underlying F1 status, because you're not allowed to accrue times of not being employed beyond the 150 for STEM OPT or 90 for the initial 12 months. The number 10, I believe another grace period question. It seems like this is in terms of an H-1B visa classification. So similar to what I mentioned before, the grace period for an H-1B is 60 days. So meaning that if there was a separation of employment, you were laid off by your H-1B employer, before there was some leniency on this, for the most part, you had about 10 days to kind of wrap up your affairs here in the U.S. and kind of leave. Now, thankfully, Homeland Security has extended that, so it's 60 days. There's some maneuverability around that number, but just to kind of play it safe, 60 days is kind of the date to keep in mind to either leave the U.S. or perhaps find another H-1B employer and interview with that employer so that they can transfer and port your H-1B to that second employer. So that's the grace period that comes with being laid off by your current H-1B employer. Mishita, did you want to perhaps handle question number 11? I believe as one of the audience members mentioned, he's a U.S. citizen, but perhaps he's looking for different assignments outside the U.S.
Right. I think, as we said, we do have a global mobility practice, and depending on which country you're looking for an expatriate assignment, we could definitely try and connect you. I think overall, given that we're not experts in the inbound immigration in either Singapore, Australia, UK, or EU, it would be difficult for us to speak, intelligently about that answer. But I assume that, quite like the United States, each of these countries would have some sort of, work visa program, perhaps some eligibility requirements. And I think immigration professionals who practice in these countries for inbound immigration will be able to give this response. So if you want to connect with us, perhaps you can reach out to Neha and we'll put you in touch with the professional that practices in that country.
Yeah, if I may just add to it, we have affiliates in all of these countries. So like Attorney Jethi mentioned, we probably don't have the expertise right here, but we do have a global mobility team that works with all these affiliates in all these countries, and I can definitely help you put in touch with them. Thank you.
Right, and then just to kind of wrap up, I mean, I suppose I, understand the question number 12, asking about the differences between joining on a contract and joining full time. So, by contract, I suppose, what I'm thinking is, let's say your employer is an H-1B petitioner, but they assign you to work at a, specific end client as a consultant. So, so if that's what the the person asking the question is meaning, I mean, your employer is your H-1B petitioner. Um, in order to get that H-1B petition approved, they have to show the bona fides that there is a genuine employer-employee relationship that exists. And even though you might be assigned to work based upon a client project with a specific end client, they would have to show that that the employer relationship is maintained. And oftentimes we do that as practitioners here. Obviously, salary and benefits are paid by the petitioning employer, but there also has to be some means of control and supervision that's conducted by the H-1B employer over that employee. It can't just be that the end client that you're assigned to work at that specific client site, has full reins to, control the terms of your H-1B employment.
And if I'll just add one more quick point. If the difference that's being asked here is about the amount of time that you work. Sometimes I think people say when they join on contract that it's like a part-time position, it's an hourly position as opposed to a full-time position. If the question has something like that, I just want to bring this up, particularly because a large section of the audience here is on F1, that the minimum requirement in terms of employment while you're on F1, OPT, and eventually STEM is 20 hours per week. So if you're on any sort of a contract assignment, a contract employment, where the number of hours that you work is less than 20 hours a week, please know that that would be a violation of your status. So you want to make sure whether it's contract or full-time usually means 40 hours a week. So I think that should be okay. But even if it's not, and if anywhere in your employment contract or conditions you realize that you're going to be working for less than 20 hours a week, please make sure that you check that out, that could be a red flag and you would not maintain status.
Right, and then I suppose that kind of segues into just a broader point that I wanted to make sure that the audience understand, especially if you're here based upon a non-immigrant visa such as the F1. Communication with your DSO, your designated school officer at your university is critical, because obviously you're just starting your U.S. immigration journey. And those I-20s that you're familiar with that are produced, with the DSO, those are essential because that serves as the foundation building blocks for kind of building up your immigration history. Once you convert to a employer-sponsored work visa status and perhaps beyond, all those I-20s are relevant. So data entry, the SEVA system is notorious for having data errors. So the DSO should absolutely be your best friend in making sure that everything is compliant, everything is entered in correctly, and that there are no issues there. Lastly, I suppose the question here, it's a fairly general question. What are the benefits and legalities to be discussed before accepting a full-time job?
And I think it also spills a lot into employment law, and I don't know if we want to necessarily be, going beyond the scope of this. I think in terms of, benefits from an immigration perspective, definitely see if you're able to discuss with the employer, what their sponsorship policy is. Because as we discussed, at the very start of this meeting, for a fact that you will require sponsorship, whether it's today or, another year or 2-3 years down the line. So when there's an opportunity, definitely discuss that. discuss if you are married, if you have dependents with you in the United States, check with the company what are their policies about extending visa status to the spouses. By extending, I don't mean obviously the fact that you're married, your spouse would qualify for the dependent visa type, but would the company cover the costs for doing it, or would you be responsible for maintaining that? You should, if you're able to discuss this, figure out what are the company's policies in terms of, giving advance notice, particularly for those on visa, how long of a notice do they usually give, and discuss, that if and when, what are the career mobility options, like we were discussing, in relation to question 7, if you're unable to get picked in the lottery in your first, second, or third attempt, what are the company's policies about relocation? Would it be that, that's it, you didn't get picked and, you're out on your own? Or will the company assist you in perhaps relocating you to another to another country, perhaps where work permit and residency is easy for you, or perhaps your home country? So I think those are some of the questions, or some of the issues that I would like clarity on from an immigration perspective if I was joining a new company. But I'll definitely not venture out beyond this on the employment law side.
Yeah, and then just perhaps kind of adding to that, Mishita brings up the topic of paying the cost. I suppose she references in relation to dependent family members. But if we're just talking about the principal applicant, there are rules that are governed that govern what party pays for what. In terms of USCIS filing fees, if that company happens to retain outside counsel, the law firm fees involved, and a lot of times, practitioners are not even familiar with those rules as well. So it's good to know what's within your discretion to inquire about. If you have a good feeling about that particular U.S. employer that's looking to hire you, you have your H-1B visa that they're looking to sponsor, but they push out all these costs to you and demand that you pay for that out of pocket. Are they allowed to do that? They're allowed to do some of that, but perhaps not all of it. And if they attempt to do that, then perhaps it might not be the company that you want to be tied to and associated with moving forward, because they're at risk of any kind of Department of Labor investigation moving forward, that they're kind of I suppose pushing out and allocating these costs when they shouldn't be doing that in the first place. I suppose that's it for the questions here that are listed. I don't know if there's any kind of audience questions that we didn't get to. If not, then Pam, I suppose we can kind of defer to you.
Just a quick one. My question is also about like traveling while on OPT, because for most of us immigrant, whereby we have 2 years visa, and in order to renew your visa, you either have to go to your home country. So like, have you ever seen a situation whereby you need to travel overseas, like during OPT, and does the EAD kind of like cover, or it's still contingent on you kind of like renewing your visa before you travel?
Mishita, did you? Well,
Sure.
there has to be a travel endorsement on the I-20. So, I suppose when an F1 student brings up the issue about traveling overseas, the first immediate question that I have is that make sure that your I-20 is properly endorsed by the DSO within the past 6 months to allow for that travel authorization. Needless to say, the actual visa, the visa foil in your passport that you receive from the consulate, the Department of State, that has to be current and unexpired as well. Mishita, did you have anything?
Yeah. So the way that I would approach this, is this: when you know that you can apply for your OPT only when you're physically in the United States, right? So make sure that if you are planning on applying for the OPT, you apply for it while you are here. And then if you wish to travel, please know that when you return to the United States, almost always the CBP will ask to see your OPT EAD card, because that sort of says that you will come back and return to an employer and work for them. So let's say if, from a timeline timeline perspective, you decide to apply for your OPT, and then, as you know, it takes about 4 or 5 months for the OPT EAD to be adjudicated. And if you're not in the country, make sure that there is someone who can actually get the EAD for you and can send it to wherever you are. I would not recommend doing this. Personally and anecdotally, I can tell you that so many things can go wrong. So perhaps the best practice would be apply for the EAD, get it in your hand, make sure that you have an endorsed I-20 and you have an unexpired F1 visa before you travel abroad. But in the circumstances that you have to travel in emergency, make sure you've applied for your OPT EAD. Make sure that you have an endorsed I-20, which is valid for at least 6 months within the last 6 months of your travel. And then you have an unexpired visa. If you plan to get your visa renewed in your home consulate, then you should still continue to meet all the requirements of F1, which means that if you have a pending H-1B petition, there's a question that can be asked about whether you're going to emigrate to the United States. Again, it's a little bit beyond, I think, what you're asking, but I just want to make sure that you're aware of all of these things.
And it's always helpful to perhaps, especially if you're working pursuant to your OPT EAD, and so you have that employer to return to. CBP is aware that obviously unemployment, especially if it accrues beyond the the 90 days and 150 days, that's that kind of risks a violation of status. So it's good to be equipped with like perhaps a letter from the employer that you're returning to, saying that upon obviously your return admission to the U.S. As an F1 OPT EAD holder, obviously you're going to be returning to that employer, and these are the terms of that employment that you're returning to, and submitting that letter along with all the documents that Mishita mentioned to the CBP officer at the port of entry upon your return.
Thank you.
Thank you for the question.
Any burning questions before we close? Well, on behalf of Stevens Institute of Technology, Dr. Sarkar, and our students, we are so thankful for the depth of experience and expertise that was shared today, and what an extraordinary experience for these students to be equipped with the information, the knowledge, and as well as the Chugh firm being a resource for the students going forward. And so, Neha, Min, and Mishita, we thank you so very much for your commitment today and for an extraordinary program. So allow me to stop sharing. Let me stop our recording.